Welcome to the weekly Saturday knowledge sharing webinar organized by Mehta and Mehta. Thanks all the participants for your continuous support. For a change, I am starting my webinar today without Century, Mr. Bala, because people will join. And honestly, today this Nidhi Companies, I was little doubtful that people will join because in cities, people don't have that hope for Nidhi Companies. And there are people who had requested us that please organize the webinar on Nidhi Company. And we earlier had the webinar, and our partner Arun had presented the same earlier. But still, Arun, this is the second time you are going to present because participants has requested us that this topic should be taken, because generally this topic is not taken in certain cities. It is request has been received, so we are organizing, and of course this is the part of our Companies Act. So we thought that, and we told them at that time we will do that when this we will start masterclass on Companies Act. And yes, today is the topic, an insight into the Nidhi Companies. The same will be presented by our Kochi partner, Mr. Arun. And Arun is a fellow member of ICSI and has postgraduate diploma in business management in finance from Jain College and Bachelor of Science in Maths. Wow, Arun, BSc in Maths, very rare it is, it's difficult. He has expertise in various spheres of secretarial advisory and plays a prominent role in corporate management, litigation, resolution of shareholder dispute, legal advisory, various type of DD, advising, implementing acquisition of control, setting up company, LLP, and advises under Companies Act, SEBI, FEMA, trademark, compounding, approval under FEMA, RBI, and so foreign investment, joint venture, wholly owned subsidiaries. So Arun is our Kochi partner, friends, and he has experience in setting up Nidhi Companies since years and handling and managing their compliance since years. So you can shoot out your questions to Arun. No issue. Yeah. And as usual, our other panelist moderator is Mr. Bala. And Mr. Bala is there and Sudhakar is there. And today's our guest and panelist is Mr. KP Satishan. Welcome, sir. Thanks for your time. Mr. KP Satishan is an associate member of ICSI and then fellow member. He is a Bachelor of Commerce and General Law. More than 20 years, he has post-qualification experience in secretarial, finance, accounts, internal audit, legal, personnel, and administrative function in private, public, and sector companies, including a reputed MNC having 7th place in the world. He has about 40 years post-qualification experience in total, and he started his practice in the year 1997 as a senior partner of Gopi Mohan Satishan and Associates, a firm of practicing CS and having branches in Tiruvantam, Arankulam, Palakkad, Kottayam, etc. Our other panelist is, he is well conversant with all company law matters, including public issues, SEBI, dealing with banks, FI, work connected with project appraisal, funding, etc. He is a founder chairman of the Calicut chapter of SIRC of ICSI and served chairman for 7 years. Oh, great. Council member of SIRC ICSI during the term 2006-2010. Widely traveled in various countries like Europe, Australia, Kenya, South Africa, Middle East, Singapore, etc. He has participated in international conference of CS in Kenya, London, Sydney, Cape Town, etc. He has contributed articles in journals of company law, education, etc. Welcome, sir. Thanks a lot for your time. And I'm sure people will get benefit of your knowledge experience for the topic. Thank you, sir. Our other panelist is Mr. Bala, as he knows, everyone, with more than 4 decades experience, regular writer in various magazines and lecturer, and he is very well known for his write-up on all decided cases under Companies Act and LODR. With welcome, Mr. Bala, we have with our own Mr. Sudhakar Saratula. Everyone knows him. He is a member of ICI, ICSI, and Institute of Chartered Secretary UK, and last worked as a vice corporate secretary department for Reliance for more than 17 years. Welcome, Sudhakar. So, and as I mentioned, today's topic is on the Nidhi's insight into Nidhi Companies compliance. Friends, not many are well versed with this topic, and that's why it's interesting to learn a lot about this. And I'll request our panelist, Mr. Satish, to say a few words on the topic, then Mr. Sudhakar and Mr. Bala, and then Arun, you can start your presentation.
When we speak of Nidhi companies, let me quote one judgment, one sentence, one paragraph, or one observation made by Honorable Justice Khalid in Supreme Court in RBI versus Peerless India Limited. What he said is, what I share my brother's concern about the mushroom growth of financial companies all over the country. Such companies have proliferated. The victims of this scheme that are attracted for put forward in public media are mostly middle class people, middle and lower middle class people. Instances are legions with such needy people have been reduced penniless because of the fraud played by such financial vultures. It is necessary for the authorities to evolve a foolproof scheme to see that fraud is not allowed to be played upon persons who are not conversant with the practice of financial enterprises, who post themselves as beneficiaries of the people. So that is the words, the observations of Justice Khalid in the Reserve Bank of India versus Peerless General Finance and Investment Company Limited. Then coming to Nidhi companies, it is a very old system. This system was prevalent even in centuries old, mainly in South India. This Nidhi companies was the basic purpose of Nidhi was mutual trust and inculcating the habit of thrift among the pure and medium class people who had no access or banking facilities at that time. Mainly in Tamil Nadu and in part of Kerala, this system started mainly by the agricultural laborers who used to deposit certain amount with the farmers or the agriculturists, and at the needy times they used to get at the time of their marriage or education of children. They used to take back this amount with a nominal interest. And this agriculturists or the zamindar, what they will do, they give this loan to needy people at a higher rate, and they take some profit out of it. That is how this was evolved in South India. Later, when the Companies Act was introduced, this was introduced in the Companies Act also. And in 1965, Section 620A was introduced to regulate the Nidhi companies. So the government felt that they should. So in 1965, the 620A was introduced, wherein the government felt that in view of the importance of Nidhi companies, certain concessions should be given to Nidhi companies, and also that there should be some regulations on Nidhi companies apart from what is needed for other companies. That is the reason why 620A was introduced in 1965. This continued, and also to create a regulatory framework for these Nidhi companies. Central government appointed 2 committees. One, Sabhanayagan committee, which gave their report, recommendation for strengthening the regulatory framework of Nidhi companies. But this was when some of the suggestions of this Sabanagan committee was vehemently criticized by or objected by this Nidhi owners of their association, and therefore subsequently government again appointed another committee, namely expert committee. So based on the recommendation of these two committees, certain changes were made. Government made separate rules were framed for the purpose of running or regulating the Nidhi companies. Up to 2013, when the Act was introduced, instead of 620A, a new separate section was introduced as 406, and the Nidhi rules was also framed under the New Companies Act, namely 2014 rules 2014, which was subsequently amended two times in 2019 and 2022. I think this can be an introduction, and Mr. Arun can continue with his presentation, isn't it?
Good morning, participants. And Deepthi, as you rightly said, when we were contemplating about Nidhi companies, we were no doubt about it. We were having our own apprehensions whether people will attend it or not, but we have been proved wrong. And at the same point of time, I must share with the participants that when we are organizing a masterclass on Companies Act, we have to see the hidden sections also. We have to bring it to light. And we will definitely do one session on the producer companies also, with, though very few people are there which are doing that, dealing with producer companies. In fact, let me honestly admit that right from my higher school days, when I was in my 12th class, I read Companies Act. From that time onwards, till date, I am reading the Companies Act, both 56 as well as 2013 Act. But very surprisingly, till this Monday, I never read about the Section 620A or the present Section 406 related to Nidhi companies. In fact, I must thank this webinar for that. When I was preparing myself, I found it quite an interesting section, Section 406. In fact, it has remembered me that the Madras chit funds, okay, that the chit fund concept was there in Tamil Nadu, it started. That's why if you see the Chit Fund Act also is Madras Chit Fund Act, which has been now, it is there. Other than that, there is no other act to regulate the chit funds, if I am not wrong. When I was discussing with Arun also that these Nidhi companies are mostly prevailing in Kerala. In fact, okay, as Mr. Satishan has mentioned that this Nidhi companies is primarily to cater the lower strata of the people who cannot have the bank financing or who cannot have, I mean, access to the loans, I mean, the small loans what they require. This particular community is being categorized by these Nidhi companies. And in fact, I must say that every company secretary has to have at least one reading of this Section 406. So beautifully the sections have organized. In fact, the controlling factors, the way that Nidhi companies are regulated. It's quite interesting.
Good morning to all of you. It is very nice to see all of you in the early morning on Saturday for the knowledge auditing session, which you have been doing it quite some time now. I'm also more privileged to meet different people and different aspects and learning the thing what is happening today. Really speaking, it is a real value addition which is actually happening to all of us. When it's come to the Nidhi company, people have already said about the Nidhi company. It is basically nothing but like a mutual trust society, I can call it actually. Although if you look at broadly, this comprises a sort of a functioning like a NBFC company, but yet it is not the NBFC company. Because NBFC company is actually regulated under the Reserve Bank of India, and it has got its own variations. It is governed by the Companies Act and as well as licensing from the RBI. But when it comes to the Nidhi company is not involving any third party. Because Nidhi company is involving only its members. That's all. Only the members who are actually there within the Nidhi company, the borrowing, lending takes place, depositing, etc., which is there without involving any third party is there. That is the speciality of the Nidhi company. And as Sudhakar also said, the Nidhi companies were popular in South. Yes, it is more so. It is very popular in South, especially in the Kerala and the Tamil Nadu. It is basically to promote the middle class and the lower middle class people the habit of saving and also meeting the need-based requirement of their funds by way of borrowing the things and mutually benefiting. That is the way it has been working. In fact, in one of the popular Nidhi company in Kerala, you all may be knowing, there's one Mukut Nidhi company there. Not only that, they created another mini Mukut Nidhi company as well. So there are companies which are actually operating in there.
Okay, thank you, Mr.
And coming to the Nidhi companies, although it is one of the special features in the Companies Act, it is very simple when you look at it, but when we get into the practical aspect of it is very difficult. One of the notification which came very recently in the April 2024, which has created a lot of records because on the Nidhi Companies incorporation was rejected. And then the notifications that, how can you actually ask for the Nidhi company unless until it is approved, only it approved has become a Nidhi company, these sort of a things which is actually there. I think Mr. Kadiresan has been handling this Nidhi company, has got a lot of practical insight on it with the decided cases and handling the things. And we will definitely have the most expert things on the Nidhi company about this. I give a stop here because I also not practically dealt with the Nidhi company. But I have an overall view of the Nidhi company. When it is come to the practical thing, it is very difficult. It is not that easy, although it appears to be what appears in the rules and regulations. That is where it is there. I'll ask Mr. Arun to have a presentation. Kadiresan, I request you, whenever the presentation goes on, as and when need arises, you may just to step in and share your thoughts, share your practical experience. You do the value addition, please. We are looking forward to that. Yeah.
Thank you, Mr. Bala. Mr. Satishan, we will wait for your comments. Participants, as usual, please put your questions in the chat box. The same will be answered in between wherever panelists fill. And if time permits, at the end of the session, you will allow to speak. So, Arun, please start the session. Thank you. Thanks, everyone.
Good morning, one and all. Our most respected Deepthi Madam, our reservoir of Companies Act, Sudhakar sir, also Bala sir, then our most beloved Sadishan sir, who is also from Kerala. I sincerely thank Sadishan sir because we have asked him. He has been very happy to be part of this webinar. He has also shared me a lot of insights into the nitty-gritties of Nidhi companies, and as we all know, a lot of experiences, diverse, which is beyond the act, beyond the rules, which is also very complicated, which every Nidhi companies are facing in South India, especially. Also, even though Nidhi companies have nurtured a lot, even has grown up beyond South also in the last few years with the advent of the new Companies Act. So, sir has given a lot of insight, his experience also. I thank him for spending a lot of time with us. And as Bala sir said, he has changed our presentation a lot.
Thanks a lot, sir.
Thank you so much, sir. So let me, with that, let me start my presentation.
So friends, today two Keralists are serving us Kerala specialist Nidhi companies because this is a specialization, I think, in this part of the country. Thank you. Welcome.
Yeah, visible, quite visible.
So, yeah, Nidhi companies are governed under Chapter 26 of the Companies Act. Section 406 of the Companies Act mentions about Nidhi. So, first, initially, let us have a look at what is a Nidhi. Even though our panelists and other presenters have informed about the Nidhi, let me say, go ahead with the rule of Nidhi. Rule 3A of the Nidhi rule states that Nidhi means a company which has been incorporated as a Nidhi with the objects of cultivating the habit of thrift and savings among its members, receiving deposits from and lending to its members only for the mutual benefit, and which complies with the rules made by the central government for regulation of such class of companies. So this is for the mutual benefit by creating the habit of savings among its members. And Nidhi company can do business only between its members and no outsider can involve in any of the activities of Nidhi. So this Nidhi, basic concept of Nidhi is on the principle of mutuality, that principle of mutual benefit. And I remember Satish House sir has said that it's a century-old financial tool which provides easy credit to rural and semi-urban areas because of the minimal banking systems which we had during the early years before this bank inclusion and all. So the companies operate by pooling the savings from the members and lends it back to members who are needy in the same community or in the same locality. Like when we look deep into this, was like in the these Nidhi companies were being operated in a particular panchayats or taluks or like that. That was the initial way it was functioning. So that limitation of the jurisdiction is mainly because of the involvement that it is dealt with members among themselves. So that access between members was the reason for this geographical jurisdiction which has come in initially, and that is being kept now also. Nidhis are also known as permanent funds or mutual benefit funds or mutual benefit societies. They are most popular in South India, and almost 80% of the Nidhi companies we can see in Tamil Nadu. So when we come to the rules, acts, and exemptions which are related to Nidhi, till 1965, Nidhi was similar to other companies in respect of the compliances as per the Companies Act. So 65 has brought in the section 620A, Sir have mentioned that. Then when we come to the new Companies Act, it is under section 406, and we have Nidhi rules to 2014, then Nidhi Amendment Rules 2019 and Nidhi Amendment Rules 2022, along with the exemption notification for Nidhis dated 5/6/2015. So the classification of Nidhis, how the classification of Nidhis is being done as per the Companies Act, it is by Rule 2, which states that every company declared as Nidhi or Mutual Benefit Society under the previous Act, under section 620A, is classified as a Nidhi. Then every company is incorporated as Nidhi or declared as Nidhi or Mutual Benefit Society under the new Companies Act. And all these companies has to comply with the new Nidhi Rules 2014 and its amendments. So let us see what is Nidhi. So here section 406 says that Nidhi defines Nidhi as a company which the central government may, by notification in the official gazette, declare to be a Nidhi, which has been modified by the Companies Amendment Act 2017. Then another definition of Nidhi is Nidhi comes under one class of NBFCs, and therefore RBI is empowered to issue directions to Nidhi. However, since Nidhis deal with the shareholders or members only and not beyond that, RBI has exempted Nidhis from the core provisions of the Reserve Bank of India Act and other directions applicable to NBFCs. Again, Rule 3A we have mentioned here. Then Nidhi companies are exempt from Section 45(1)A, requirement for registration on net own funds. 45(1)B, liquidity maintenance. 45(1)C, creation of reserve funds of the RBI Act, vide the circular. Then Nidhi companies are regulated by MCA. So only regulator for Nidhi company is the Ministry of Corporate Affairs through the Register of Companies. There is no other regulator for this Nidhi directly involved. Even though Nidhis are regulated by the provisions, they are exempted from various provisions as applicable to other companies due to the limited operations among its members. Let us have an overview of the regulators of non-banking companies. See, non-banking companies which are regulated with RBI, non-banking companies regulated by other regulators, then other non-banking, non-bank financial companies. So here we can see that which are registered with the RBI, the regulation, supervision, surveillance and enforcement is done by RBI. Other non-banking, non-financial companies are regulation, supervision, surveillance under the Companies Act 1956, and the regulator is the Ministry of Ministry of Corporate Affairs. Then comes the NBFC by other regulators, which are like the housing financial institutions regulated by the National Housing Board, a bank, then merchant banking companies, VCs, stockbrokers, CIS, which are regulated by the SEBI, then Nidhi and mutual companies, which are regulated by the MCA. Then comes the chit funds, which are regulated by the various state governments. Then comes insurance companies, which are regulated by the IRD. So here comes the applicability of Nidhi Nidhi on this Nidhi companies. Every company which has been declared as a Nidhi or mutual benefit society under 620A, we have already mentioned this. Every company functioning on the lines of a Nidhi company or mutual benefit society, but has neither applied or has applied for and is waiting for notification to be a Nidhi or mutual beneficial company under 620A1 of Companies Act 1956, the previous act, and the now every company incorporated as a Nidhi pursuant to 406 of the act, declared as a Nidhi or a mutual benefit society under 406 1A of the Companies Act. So here are the key definitions under the rules of Nidhi. We have the branch. Branch is a place other than the registered office of Nidhi. Then doubtful asset, loss asset, net on funds, non-performing assets, standard assets, substandard assets. These are the...
May I interfere here? 1 second.
Yes, sir.
In this branch, this definition of branch that was incorporated in 22 amendment. Why? Because earlier there is a restriction in opening of branches of Nidhi companies. You cannot open a branch unless you make profit for a continuous period of 3 years consecutively. Then only you can open a branch. That is also within the place where the registered office of the company is situated. And in many cases, Nidhi companies, what they used to do is they open branches and they will label it as collection center or facilitation center, etc. So in order to curb this practice, branch has been defined as a place other than registered office or Nidhi. So even if you designate it as collection center or facilitation center, you cannot open any office other than the registered office after the amendment of 2022. Okay, you can continue.
Sorry. Yes, sir. When you said that, I remember I had come across one Nidhi wherein there were around 200 collection centers, not branches. So this collection center route was being used as a camouflage, and it was performing like a branch. So I think with the 2022 amendment, the Nidhi cannot have any collection centers.
That is right.
Yes. Then these are all definitions which are as per the Nidhi rules. So I'm not going into all these aspects in detail. These are all easily understandable. And only thing which we have in this mainly concerned with the Nidhi, right from incorporation, is the net on funds of the Nidhi. Net on funds is being defined by the Nidhi rules, and this net on fund is a basic calculation which shows whether the Nidhi is running as a Nidhi or not. That we will come in detail in the further slides. Now let us have a look into the incorporation related compliances of a Nidhi company. It should have a minimum capital of 10 lakhs, if Nidhi is in existence prior to the commencement of the Nidhi Amendment Rules 22, it shall comply with this requirement within a period of 18 months. Then the second point is Nidhi shall not issue any preference shares. If Nidhi has issued preference shares in the previous act, the same shall be redeemed, and the rules prescribe a particular time period based on the ratio of these preference shares and all. Then the third is the object in the memorandum of the Nidhi company shall not include anything other than the object of cultivating the habit of thrift and savings among its members, receiving deposits from and lending to its members only for their mutual benefit. And the fourth important, most important point is it should have the word Nidhi Limited as part of the name. And when we say about this minimum paid up capital, this even though the minimum paid up capital is 10 lakhs, we require 20 lakhs to start the Nidhi company. That is because of the net on funds requirement. Ideally, we had a discussion. I think Satish sir will tell we need minimum 22 lakhs to start. Sir, you can share your views on that.
So even though the Act prescribes 10 lakhs, when we apply for NDH, which is within 120 days from the date of incorporation, the net on fund should be minimum 20 lakhs. So 20 lakhs should be, at least 20 lakhs should be the minimum paid up capital, even at the time of incorporation. But for the incorporation purposes and other expenses, that also we have to take into consideration. So at the time of incorporation itself, we have to advise our clients that your capital should minimum 20 to 25 lakhs. Then only we will be able to satisfy the condition of minimum net worth of 20 lakhs within 120 days from the date of incorporation when we submit the MDX4 form.
Thank you, sir. Then we come to the NDH4. This is the latest requirement inserted by the 2022 amendment, wherein every Nidhi, once incorporated, it should apply and get this approval of these conditions by filing form NDH4. Post approval of NDH4 only they can apply for commencement of business. So here, every Nidhi shall be a public company, and the public company shall apply to the central government in form NDH4 for declaring it as a Nidhi company. The central government on scrutiny, if they are satisfied, they shall notify the company as a Nidhi company. If Nidhi company is incorporated on or after the commencement of the Nidhi Amendment Rules 2019, it shall file form NDH4 within 60 days of the date of expiry of 1 year from the date of its incorporation, or the period up to which the extension of time has been granted by RD. This was as per Amendment 2019. Nidhi Amendment Rules 2019 said this. And now Nidhi Amendment Rules 2022 states that the declaration procedures of Nidhi companies shall be followed as per the step 1, which is based on the application in form NDH4, which says that when you apply for this approval of central government through form NDH4, there shall be 200 members, net on funds of 20 lakhs or more should be there. Promoters or directors are fit and proper person, that should also be part of the declaration. So this declaration is to be done before the commencement of business. Since this is to be done before the commencement of business, the minimum 10 lakhs does not have any implication on if we go with the minimum 10 lakhs, capital, we will not be able to make this declaration. All this shall be done immediately on incorporating the Nidhi company. So once this application is submitted to the central government, after complying with all these aspects, if there is no response from the central government within 45 days, it is a deemed approval. And practically, let me tell you, there have been cases wherein before this 22 amendment, while this Nidhi Amendment Rules 2019 was in effect, even there are few conditions which we have observed, wherein after 45 days also, this central government have rejected and said that Nidhi cannot function. So there is a fear among the Nidhi companies even after 45 days of this deemed approval. That is what I would like to state. Sir, you have any comments on that?
Yeah, I would definitely look forward from Mr. Satishan, because the whole idea is, I think when I was talking to some of the people, they think NDH4 means it is something like a license which is issued similar to RBI, which is actually not the case. Because NDH4 is only the filing, and it is the approval is actually given that declaring that this is the Nidhi company, that is the thing. And as you rightly said, here after 45 days, if nothing is actually deemed to the approval, but there are cases, even after the 45 days also, there is a rejection, etc. is there. But only thing is, unless until the approval is received, the Form 20A cannot be filed actually. Why only 20A? Even 20A cannot be filed, SS7 cannot be filed,
SS7
BS3 cannot be filed, nothing can be done.
Nothing can be done, sir.
Yeah. So really speaking, how do we actually go about all this thing? Another thing is that the reaching of 200 members, is it required before filing the 20A? How do we reach? I look forward to hear from Satish.
But when the 2020, after 2022 amendment of Nidhi rules, they say that you should have a minimum 200 members. Net total fund should be 20 lakhs, and promoters and directors shall be proper, fit and proper persons. So what that means, apart from the conditions contained under section 164, they have added some additional conditions for acting as a director of the company. Like a person can be a director of any only 5 Nidhi companies, and a person can promote only a promoter of 3 Nidhi companies. Like that, certain stipulations have been incorporated in the rules itself. Here, in most of the cases, what they do is, within 45 days, they will send a standard rejection letter. And as per my information, only 3 companies have been, NDH4 of only 3 companies in all India has been approved as on date. One is very famous Kumbakonam Nidhi company in Tamil Nadu, and one in one Punjab related company. I don't know the name of the company, and I think one Kerala-based company. These are the only 3 companies whose NDH4 have been approved by by the ministry so far. All others, there are about 1 lakh Nidhi companies in India. Out of this, only 3 companies NDH4 have been approved. All others are standing on the fire.
Do you think there is a bureaucratic things are happening instead of, because one side we are talking ease of doing the business, and
Definitely.
we say it is very simple to incorporate. Yeah.
If we go through their letters, rejection letters, most of the letters, the rejection letters are funny and absurd, because the reasons for rejection, what they quoted by the MCA, if you go through it, we will feel sorry for the officer who have signed that document. In one, I'll tell you, in most of the cases, the one reason for rejection, what they have stated is, minimum there are more than 200 members, because there should be minimum 200 members. The company has such and such members. Out of this, the promoters all the 99% shares, and the balance 197 or 200 members all the 3% shares or 5% shares. And that is for that reason, this cannot be treated as a Nidhi company. That view is absolutely absurd. because when you incorporate a company with 7 members, they have to subscribe for 25 lakhs or 20 lakhs or 25 lakhs minimum. And the shares will be in their hands. And as per the Nidhi rules, a borrower has to take share for 1 share only of rupees 10. So normally what these people do, these promoters do is, they add 200 members within a period of 120 days. Most of these people might not have taken any loan from this company. Just they add for the sake of getting or applying to the MCA for getting the NDH for approved. They add 200 members, and they may be relatives or their associates of these promoters with a 10 rupees shares. So in that case, this 200% can maximum can hold only 3% or 4% and not 50% or more than 50%. So the stand taken by MCA that that a company cannot be treated as a Nidhi company only because 200 members are holding minority shares and these promoters are holding majority shares itself is absurd. And another objection what I have seen in many cases is that the promoters are the directors of this company are the directors of some other companies, not Nidhi companies, and therefore they are disqualified. This is also absurd because the Companies Act, you can be a director of 20 companies, and even under Nidhi rules, you can be the director of 5 Nidhi companies. So by virtue of one person being a director of any other company, if they are rejecting it, it is absurd. So these are the instances. If you go through the rejection letters, you will see that they have done it deliberately, or this rejection was not based on any scientific ground.
Federation, I have got one small question to ask on this. Normally, what happens is when we apply the name, the name itself is actually approved while applying the MCA, correct?
Yes.
When we apply for the Nidhi company, our name is approved. When already the name is approved at the time of the application, when the name, then at the time of filing the NDA, it is a Nidhi company or otherwise. But why can they say that we are rejecting it?
No, NDH4 is rejecting, they are rejecting it based on some other conditions. As I rightly now said, because of the many absurd reasons which they may adduce for rejection of this. So they are finding reasons for rejecting this NDH4. But recently, in last April, they have rejected a name application saying that you cannot apply for a name with Nidhi unless it is approved by Nidhi. How can it happen? You cannot apply for a name, or before applying for a name, you cannot get the word Nidhi approved by the ministry.
I think here Satya Krishna is put up the same question here. Our Nidhi company was rejected at the final step with the same remarks. Word Nidhi Limited is not considered until approved by the ministry through the filing of the NTH report for being declared as a Nidhi company. Once concerned company will be declared in Nidhi, then only the words Nidhi Limited can be used. How can they reject the same remark when the name itself is approved to the MCA and NDHL after the incorporation? That's what he is also raising.
That is right. Actually, I think MCA itself has to examine the reasons why they are rejecting, why some officers are rejecting this Nidhi companies NDH4 without any valid ground. So this is a matter to be examined by the ministry itself. Because the government has introduced this, or the act has introduced this scheme, this Nidhi, with much fanfare and with an intention, because this helps the rural economy, and especially in northern India, and the spreading of this branches of bank branches that may be limited as compared to South India. In those places, Nidhi can play a very good role for the upliftment of rural economy if it is properly used.
And to add to that, sir, one more thing is that this NDH4 has come into existence only with the Amendment Rules 2019. Before that, there was no NDH4.
Yes, it was only NDH1 only.
Yeah, and this NDH4 is the villain of Nidhi Companies now.
Then what is the option available after the India 4 is rejected? Whatever the reason it is.
In Kerala, some of the Nidhi companies, they have gone to the High Court, Honorable High Court, and recently, last week, April last week, they passed an order also, giving certain concessions to Nidhi companies. They said that they had to submit the NDH for afresh, curing all the defects what they have pointed out by the ministry. But most of the defects that have been pointed out by the ministry is quite absurd.
And also this few of the rejection reasons which we have seen is beyond the Nidhi rules. Like if the company has not filed MGT 14, NDH4 is rejected. There have been such cases also.
Not only NDH 14, in some cases they say that your balance sheet, when you file the balance sheet, you approve the balance sheet of public limited company, you have to file MGT 14 within 30 days. So in some cases, they might have failed in filing NDH MGT 14. In other companies, what they do, we file it with additional fee. Even accepting this MGT 14 with additional fee, now this is a ground for rejecting NDH4, which is absurd, unjustifiable.
Yes, sir. So step 3, after the central government application is being accepted by central government, if deemed approval is there, otherwise if it is approved, it shall be notified in the official gazette. So I think as Sir said, only 2 or 3 notification has come in the official gazette. All others are issued approval.
Here also, I would like to interfere. And what they do is, instead of sending letters for the rejection of this NDH4, initially after getting within 7 to 10 days of getting the NDH4, they send an email to the company saying that you have such and such defects, followed by another maximum 2 emails they are sending. They are not sending any letters before that. And finally, a letter comes rejecting the NDH4. So before rejection of NDH4, they are not sending any letters. So in many cases, these people may not look the this email also, so that they are not getting an opportunity even to explain why or to cure the defects noticed by the department. That is what is happening now.
I think we have spoke almost all. These are the effects of the NDH for non-compliance. As per the Nidhi Amendment Rules 2019, if NDH4 is not filed, the company shall not file SL7 Pass 3. With this new Amendment Rules 2022, if Nidhi does not comply with the Nidhi rules or if the NDH4 is rejected, it shall not raise any deposit from members, it shall not provide loan to members. The effective date of non-compliance will be the date of non-compliance, date of commencement of rules, date of rejection of NDH4, whichever is later. So this means that non-compliance of NDH4 will bring the company to a complete stop. Then these are the additional requirements post incorporation of the Nidhi. Requirements which shall be fulfilled by Nidhi. Ideally, these provisions have still there in the rules. That's why we have brought this in the presentation. But in effect, NDH4 overrides all these things. So here we can see that the post incorporation compliance, first year financial year compliance, Nidhi shall file form NDH1 within 90 days from the close of first financial year after its incorporation. This is not applicable now, but still it is the part of the rules. And the non-compliance part, post-incorporation compliances. Part of the post-incorporation compliances, previously there was an option to file for extension to the RD and get time to make the compliances of not less than 200 members, net on funds, unencumbered deposit and ratios good. There was a time period given before. Now this time period as such is not applicable because NDH 4 has come. At the same time, the rules, this is the rules also. That is why this is being brought in here. Now let us go through the general restrictive provisions of the Nidhi company. So the Nidhi company, they shall not carry on the business of chit funds, hire purchase, leasing finance, insurance or acquisition of securities issued by anybody. They shall not sell or they shall not deal also with this kind of activities. They shall not issue preference shares, debentures or any other debt instruments. They shall not open any current account with any of their members. They shall not acquire or purchase securities or control the composition of board of companies of any other company in any manner whatsoever, and that is without the prior approval of the registrar regional director and also with a special. And point number E, they shall not carry any business other than the business of borrowing or lending in its own name. They shall not accept deposits from or lend to any person other than its members. Now, the assets shall not be pledged. Assets which are lodged with the Nidhi as security for loans shall not be pledged by the Nidhi company. Shall not take deposit from or lend money to any body corporate. Shall not enter into any partnership arrangement in its borrowing or lending activity. So, whatever the Nidhi company lends shall be from the pool of funds which is collected from its members only. They shall not go outside to get funds for lending. Then the next one is issue or cause to be issued any advertisement in any form. Nidhi shall not make any public advertisements. At the same time, they can issue advertisements to their members about their schemes of deposits, loans, everything through private circulation mode. Also, they shall not pay any brokerage or incentive for mobilizing deposit from members or for deployment of funds or for granting loans. They shall not raise loans from banks or financial institutions for the purpose of advancing loans to members of the Nidhi. So this is like a self-closed group. Here comes the share capital allotment, then the members aspects. We have covered a part of this, still we will have an overview. Every Nidhi shall issue fully paid up equity shares of the nominal value of not less than 10 rupees each. Nidhi shall not deposit, shall allow to each deposit holder at least a minimum shares of 10 equity shares or shares equal to 100 rupees. This is for a deposit holder in a Nidhi. If I as a member of Nidhi, if I want to transact with Nidhi, I shall do this with 10 rupees. I think that there were cases of rejection related to this also. Then membership of Nidhi, no body corporate shall be admitted as a member. Minimum membership of 200. Minor cannot be a member of a Nidhi. The transfer of shares by members are restricted to 50% of the holding of the particular member if loan is availed from Nidhi by such member. Here comes the net on funds. Every Nidhi shall maintain.
In fact, Arun, if you see
Yes, sir.
the amount of restrictions what a Nidhi company is having, so beautifully they have what's called as kept the basic fundamental obligations of the Nidhi companies intact. They are not allowing them to do everything and anything available under the sky. This is the most beautiful part which I have observed in Nidhi companies. Yeah.
Yes, sir. Yes, it is like a self-help group. They cannot look beyond the circle.
Sudhakar, you are right actually, but the problem what is happening in practically, most of the Nidhi companies approval are not taking place. Rejections are coming actually on the flimsy ground. That is the issue. As Kadresan has actually
There's,
put it, they have even gone to the
I
High Court
appreciate,
and
I appreciate that, Bala, but there might be some reason for that. Okay, suppose if the Nidhi companies they are not approving means, I don't know. There must be some reason for that. Without reason, never the governmental departments will do just for the heck of doing that. What is the reason for that? I don't know. Because see, one thing is there definitely in the good olden days, there used to be blade companies in Tamil Nadu. Blade companies, you know that very well. Okay, that the fly-by-night operators normally they used to operate. The Madras Chit Fund Act, if I am not wrong, that is the result of that only. Prior to that, there was no regulations to regulate the chit funds. So what people used to do was just to run for 1 or 2 years that the chit funds, and then the third year, they mobilize the funds, and then they used to fly-by-night operators kind of thing. So most of those companies used to be called as blade companies. Okay. So I don't know whether in case of Nidhi companies, Mr. Satishan may throw some light on that. What would have been the reason for that if the regulators are rejecting the applications before incorporation itself or in between the Nidhi companies are getting operated? I don't know because RBI is also quite stringent as far as the NBFC norms are concerned. If any NBFC is not complying with the prudential norms or something like that, they give some 2-3 warnings and after that they too cancel the registrations. Yeah.
suppose that I don't know, Kadresan may throw some light on that because it appears, I'm not very sure about it. Suppose there is a fear, the Nidhi company is like that of the competing with the NPSC company. They wanted to promote the NPC company more rather than the Nidhi company, and more the Nidhi companies are most popular only in southern part of the country, not in the other part of the country. This is the talk I hear from some people. I don't know how far it will be true or not because regulator cannot act discriminately to each type of the companies because each company has got its own rules and regulations. They're not within the ambit of the rules and regulations they have to do. But in spite of that, practically there is an issue. Your view, Kadresan, on this?
I have also had allegations like this because they are influenced by NBFCs. Because once this Nidhi company grow, that may affect the business of NBFCs, and definitely it will affect the gold loan, etc. Point number one. Point number two, as rightly pointed out to Mr. Arun, one of the reasons this rejection, NDH for rejection is they are saying that you have allotted shares for 10 rupees shares to many of your members, which is in violation of the provisions of the Nidhi rules, which says that there should be minimum 100 shares for members should hold shares for rupees 100, which is wrong because legislative is very clear. It says that the persons who take loan from the company, they need to hold shares for rupees 10 only, and only those shareholders who deposit the shares in the company, the deposit with the company, they only need to take shares for 100 rupees. So they cannot equate these deposit holders and the lenders or the borrowers, the borrowers equally. So the act is very clear that if you take loan from the company, in the company, you need to take shares for rupees 10 only. And if you deposit with the company, then only you take shares for rupees 100. But NDH4 is rejected on the ground that all the shareholders are not holding shares for 100 rupees, which is ridiculous. So that is then people may apprehend or people may suspect that these people are rejecting this NDH4 on some other extraneous grounds, and we do not know what these extraneous grounds are.
And sir, to add to that, see these NBFCs when they if we look into this, especially Kerala and Tamil Nadu, NBFCs have grown to every small village. Every small village you see, they will find an office of Muthoot or Manappuram or similar kind of NBFCs in South. And what happens is that Nidhi being operated by its own members, when the small community groups are forming their own Nidhi companies in every nook and corner of the state, what happens is that they will go to get loan to their own company, and these NBFCs, the business of NBFCs are drastically come down also. So this can also be part of the reason why Nidhi is being classified or kept separately or being given up this kind of regulatory pressures, we should say. So let us continue with the net on funds requirement of Nidhi, that every Nidhi shall maintain net on funds of not less than 20 lakh rupees or such higher amount as the central government specified from time to time. This 20 lakhs have come in from this new latest amendment. Then provided that every Nidhi existing as of the date also has to comply with this new 22 regulations. And being a Nidhi, see, practical difficulty is that when they are complying with the 10 lakh rupees net on funds, which is maintained by small groups of members, it is not easy for them to immediately raise the net on funds to 20 lakhs. Because these are all maybe 200 members would have joined with this 10 rupees or 20 rupees, and they will be running the show for this by sharing the equal ownership. So there is a practical difficulty in maintaining this net on funds with the change of rules which affect the functioning of these Nidhi companies also. Then
Sanjay
comes
Krishna is actually sharing. I got a query from the other practicing member that even the run application also getting rejected with the same comments.
yes, sir. That is happening from April, as
That is after the circular is issued.
Yeah,
after the new circular is issued by the MCA.
Yeah, but after 2022, I think nothing else has come officially. But unofficially, we hear that the word Didi is not being.
I don't know, because he says, in fact, he is also asking, if possible, kindly allow me to speak. You want to share something. Anyway, since we are asking the people to talk in the end, we will ask him to speak. But that's what he says now.
Yes, yes, sir. Yes, that there is that issue now. Now we heard that the word Nidhi itself is not big, but this is again going to the CRC. We don't know why it is happening from CRC like that. So let us go through the branches of Nidhi. Conditions to open the branches are very well specified. Branches shall not be beyond the state. So Nidhi operation jurisdiction is within the state. Acceptance of renewal leads to violation of the prescribed ratio. So unless and until this particular ratios are not maintained, then the Nidhi will not be able to accept any new deposits. The ratio in subrule 2 shall also apply to any incremental deposits also, like recurring schemes and all. These are the various contents of the application form for accepting deposits. So when a Nidhi company goes to accept deposits, the form should be accompanied by these much details. If we go into this, we can understand that every details of the company is being part of the application for acceptance of deposits of every Nidhi. This is a very strict compliance which every Nidhi has to follow. Name and date of incorporation, the business carried, the information of the various heads mentioned below, like management information, net profit details, dividends details, deposit details, summary of the financials. So all these are to be made part of the deposit application form. Along with these statements also, in case of non-payment of deposit or part thereof as per the terms and conditions by the sorry. In case the application form shall also contain these details. The deposit, in case of non-payment of the deposit or part thereof as part of the terms and conditions by the Nidhi company, the depositor may approach the bench of the NCLT having jurisdiction over Nidhi. So this shall be part of the form. In case of any deficiency in servicing its depositors, they may approach the redressal forum as the case may be. That the declaration made by the board of directors and directors of Nidhi as disclosed of the representation made in the application form are true and correct, and this is not insured under the repayment of deposits are not guaranteed by the central government or the RBI. This shall also be, the statement shall also be there, and a verification clause by the depositor stating that he has read and understood the financial and other particulars published and representations made by Nidhi in his application form, and after careful consideration he is making the deposit at his own risk. Then the conditions for fixed deposits shall be for a minimum period of 6 and maximum period of 60 months. Even if it is a fixed deposit or a recurring deposit, it shall be for a minimum recurring deposit shall be, sorry, fixed deposit minimum 6, maximum 60, recurring minimum 12, maximum 60, recurring deposit in case of recurring deposits related to any loans which is being given as loan to which is being given as security to any loans, the maximum period of the recurring deposit shall correspond to the repayment period of such loans granted by Nidhi. Then the maximum balance in a savings deposit account at any time qualifying for interest shall be only 1 lakh rupees. Suppose if one member has a deposit of more than a lakh in his savings account, he is eligible to get interest up to that 1 lakh rupees. Beyond that he will not be eligible to receive any interest. Then Nidhi may offer interest on fixed and recurring deposits at a rate not exceeding the maximum rate of interest prescribed by the RBI, which the NBFC can pay to their public deposits. Here also, a fixed deposit or a recurring deposit shall be foreclosed by the depositor. Conditions are laid down for that also. Here comes the unencumbered term deposit. Unencumbered term deposits are deposits which shall be maintained by the Nidhi company. 10% of the outstanding deposits at the close of the last working day of the preceding month. That is how the Nidhi should calculate the unencumbered term deposit. And this shall be deposited with a scheduled bank, and it will serve as a security. Scheduled bank, post office in its own name, will stay as an unencumbered term deposit as a security to the depositors. Then the withdrawal of term deposits, this unencumbered term deposit can be withdrawn subject to approval of RD by obtaining a permission by applying through NDH2. Condition and time limit may be specified by the RD to ensure the restoration of the prescribed limit. So, in case of business emergency, they can go ahead and they can withdraw part of this unencumbered term deposits also with the permission of RD. Then comes the provisions for loans. Loans can be provided only to its members. If the joint holding is there, loan shall be provided to member whose name appears first in the register of members. Any default in earlier loan is there, he will not be eligible for any loans. And limits for loans which can be given by a Nidhi company is well defined here. If the amount of deposits of the Nidhi company is less than 2 crore, one loan cannot be more than 2 lakhs. Similarly, up to 50 crores, 15 lakhs. Then the conditions applicable to security. See, only secure loans can be given by a Nidhi company. Gold, silver, jewelry, etc. can be used as security for loans for which the repayment period is less than 1 year. So, one of the main reason why Nidhi has thrived in southern states is because of the huge pool of loan gold available with the people, which regular small households, any requirement of fund, they will immediately run to these NBFCs, keep this gone, pawn it, and they will come with the money. So this Nidhi companies, once they started growing up in large numbers, this gold loan, silver loan, jewelry loan have become a big business for them. And that has also indirectly impacted the business of NBFCs. Then there can be a loan on immovable property, which shall the condition is that loans granted shall not exceed 50% of the overall loan outstanding on the date of approval, and loan is limited to 50% of the asset value. Loans can also be given by Nidhi company on FDs, NSC, government securities, insurance policies, etc., provided the maturity date shall be within the period of the loan. Here the rate of interest, maximum interest not to exceed 7.5 above the highest rate of interest offered on deposits by Nidhi. And calculation is also well defined. Reducing balance method. Display of the rate of interest shall be made compulsorily at the registered office of the Nidhi. Then rules relating to the directors. Director shall be a member, hold office not exceeding 10 consecutive years or such extended tenure if it is approved by the RD through central by the RD. Is eligible for reappointment after 2 years of his cessation. A director shall comply with section 152 and not disqualified under 164. Okay. Then comes about the dividend. A Nidhi shall not declare dividend exceeding 25% in a financial year. Then terms of appointment of auditor, not more than one term of 5 consecutive years, eligible for subsequent appointment after the expiry of 2 years from the completion of his term. If it is an audit firm, not more than 2 terms of 5 consecutive years. Then every Nidhi has to compulsorily file this half-yearly return in form NDH4. This half-yearly return is to be certified by a company secretary or chartered accountant or a cost accountant. And this half-yearly return will state the deposit details, loan details, and membership details. And there is a prescribed format for giving the details of each member. So this is a very cumbersome work also. And if you many of the NDH4s have been rejected for delay in filing NDA3, and this delay is being this after due to delay additional fees is being given and filed. Still that late filing is taken as a point wherein NDH4 rejections have come a lot. Also, there have been rejections of Nidhi companies NDH4 because the auditor has failed to give the certificate as per the Nidhi rules. I have a matter wherein just the auditor has given the certificate in detail, but he has not provided on top certificate. Every content, whatever as per the certificate is there in the whatever is required as per the certificate is there in his certificate, but he has missed to write certificate on top. Just because of that certificate word is not there, the NDH4 was rejected and the company had to file 75,000. Compounding was done at 75,000 rupees. So this is a very important document, filing of this auditor certificate. Then power to enforce compliance as we find in every part of the Companies Act. For the purpose of enforcing compliance with these rules, the registrar may call for such information returns from Nidhi as he deems necessary and may engage the services of a CA, CS or CMA in respect of any Nidhi which has violated these rules or not filed to function in terms of the memoranda or articles of association. Central government may appoint a special officer to take over the management of Nidhi, and such special officers shall function as per the guidelines of the central government. These are under the powers to enforce compliance. Compliance with Rule 3A by certain Nidhis. This Rule 3A, we have already made a discussion on this Rule 3A, wherein the Nidhi has to file Form 3A to ensure that they get the license, we can say license to go ahead and function as a Nidhi. So if the company, if the Nidhi companies declared as Nidhis under previous company law has to also file the NDH form. So companies declared as Nidhis under company law to file NDH form, we have said that if any provision in here we will say about the contravention, any provision is contravened by Nidhi, the company and of every officer shall be in default, shall be punishable with a fine maximum up to 5,000. And if contravention is a continuing one, further fine which may extend to 500 rupees for every day. So this is the as per the rule. This is the rule for violation of the Nidhi rules. Here we will go across the forms which shall be filed, important forms which shall be filed by Nidhi companies. NDH 1, which is to be submitted to ROC within 90 days from the close of the first financial year. We have said that this has become irrelevant post the 2022 rules. NDH 2 for extension of time for filing NDH 4 now or closure of branch. We don't know how, even if we file these forms, what will be the result.
But NDH 1 is not required now, I believe, correct?
NDH 1, I request Sadish sir to say because
NDH 1 is not required post 2022 amendments.
Yeah.
NDH 1 is not required, but they have substituted NDH 4 in place of NDH 1.
Correct, that's it. Because after that, NDH 4 has come, NDH 1 has no relevance.
No.
Not relevant. No.
Yeah.
Not relevant.
Then NDH 3, 2 we have mentioned, NDH 3 half yearly return, NDH 4, NDH 5 format of advertisement while closing a branch. Then DAR told for change in directorship, pass 3 for allotment of shares, MGT 14, all special resolutions, resolution for appointment or reappointment and payment of remuneration of manager personnel, and wherever we are filing, we are allotting shares now, MGT 14 is required. Actually, this was considered as an exemption per se. Then SH 7 is required to be filed for required to be filed by Nidhi companies. DIR 3 KYC form, INC 24, INC 22, INC 20 is filed only if we get NDH for approval. Then MR 1. So these are the various important forms for Nidhi companies. Now we will have a look at various matters related to the maintenance of book shall be as per the Companies Act, section 128, can also be maintained in electronic form, and the record keeping shall be made for a period of 8 years. Accounts of Nidhi period extended to a maximum, they can extend to 15 months. Compliances related to accounts as per Companies Act, Section 129 and 96. AGM every year, auditor to be placed in AGM, auditor certificate to be annexed to the audit report, which is mandatory for Nidhi companies. And if there is any non-compliance, that shall be highlighted. 129 and 96 again applicability same for other companies. Section on max period, we have discussed this before. Now various other illustrative matters which shall be considered by the while doing his auditor certificate. Acceptance of deposits or providing loans only after approval of NDH4. Minimum capital and net on funds met. Net on funds deposit ratio is maintained. Has not issued preference shares. Mobilizing deposits and content as per application form. Mobilizing deposits and content of application form is also as per the regulation. So these shall be part of the auditor's comments. He shall ensure that these are all checked. Now, sir, we come to the final part of the analysis of the rejection matters. I think Satish sir can throw his light on that. We have also discussed most of these points of the various rejection marks during our presentation. The ratio of net on funds to deposits is more than 1:2. Many Nidhis actually saying when we look into the Nidhi rules, there is a scope for new Nidhi companies to get compliant with this in the initial period of 2 years as per the rules. But I believe that 22 has deleted, has not deleted that, but 22 has made it irrelevant. Then delay in filing NDH1 or NDH3 has been a reason. Even if we file with the MC only with the additional fees, but MC accepted that and that was taken some fiction. Auditor certificate part I have just mentioned. Sir, anything to be you have to mention here?
In fact, people will be more interested how to sort out the ADH4 rejection, how to actually overcome it. That is what more people are interested.
In Kerala, they have gone to High Court.
They have gone to the High Court.
And High Court has given another opportunity for them to submit NDH4 after curing all the defects pointed out by MCA.
Sir, only one thing, my suggestion is that I haven't seen this particular issue on any WhatsApp groups, any representation to ICSI. I suggest, Arun, that you may take up through SIRC or wherever it is to ICSI, make a representation to take up this matter with MCA. Because filing a writ in the High Court, that is fine, but how many days it will take, we don't know. But from ICSI side, it is a genuine difficulty facing by the company secretaries. So why not to make a representation to MCA through ICSI?
Yeah, that is a very good suggestion. Actually, I think we should
Yes.
take it up with the ICSI and ICSI should take it up with the MCA.
That will be very helpful
Yes.
because now even the word Nidhi you cannot even incorporate a company.
And if you go to the rejection letters, engage for rejection letters, most of the points are irrelevant and they are too harsh in rejecting it. If rejection of NDH4 means killing a company, because once it is rejected, you cannot go ahead with the project or go ahead with your business activities. So before killing a person, he should be given at least an opportunity of being heard. That is not being done now.
So, Mr. Satishan, what I request you is, being a senior member of the profession and practitioner, so you may also write in your personal level also to the president of ICSI, take up this matter with MCA. Because in the past, several times, several matters like this have been taken up with MCA through ICSI and they were all have been addressed. MCA gives definitely a hearing to ICSI's representations. So my submission to all of you is that take up to the appropriate channels and maybe through personal level also.
Yes, we can definitely we can do that.
Definitely, sir, definitely. So the next reason of rejection, sir have mentioned about this. All promoters holding 99.90 of the shares, so only 0.10 is there with the other party, outside promoters. That was one reason where rejection was made. Then PAN of members, actually saying there is a great difficulty for Nidhi companies to collect PAN because many of their members are poor people. So these people may not even hold one bank account, and these will be very remote places. So Nidhi are insisting on PAN for deposit takers and loan, or for being a member itself. I believe there is a requirement of PAN, which is not met by many of them, is because most of these people who live in the remote place, they don't have a PAN. So that has also been taken as a reason for violation. And when this NDH4 is rejected, this Nidhi companies, whichever is being run, what has happened is that many Nidhi companies are being run by promoters who run other business also in this small localities. And when this Nidhi NDH4 is rejected, and these Nidhi companies may have around 10,000, 15,000 members, have a pool of around 6 to 10 crore of deposits in the small localities. And when this NDH4 is rejected, a lot of panic has happened in the local society, and the promoters who run the business, they are also being impacted a lot, because when this immediately the Nidhi company stop accepting the deposits or giving loans, there is a fear among the general public, okay, that there is something problem with the company, and entire promoters business are also being impacted for no reason of them. So that is also one important aspect which I thought we should discuss here. So these are the various aspects with respect to the Nidhi rejection, and I hope most of the points we have covered here. So thank you so much. Any questions? I think Bala sir, you can.
Yeah, we can take up the question, but one more thing, you also know, I don't know, because sometime back I saw the news. What do you call, there is a company called the Madras Mutual Benefit Permanent Account Fund Limited, where they, suddenly stopped refunding the deposit, this, that, etc., and other thing, and all the matter went, and a lot of complaints have been made. And suddenly they said, no, we have received a lot of, refund of the money, etc., and other thing, and all of a sudden, if we get so much of the request, we are not able to maintain the thing. That is why. That is the reason they have given. But there are also news items which has been associated, some political party leader, etc., and all these things, the funds which have been there has been actually misused by those people for the political reasons, etc. That was also the news. I think now they are lodged a complaint to the High Court, I think so.
Okay, sir.
Okay, let us have a look at the questions, whatever is there. Let me start from the very beginning. Arun Vaibhav is asking, can a Nidhi company buy land or building?
Yeah,
I haven't
Nidhi
seen any
company.
prohibition as such.
Just like any other company, Nidhi company can also acquire any assets, including
Yeah,
land.
yeah.
And
I haven't seen any prohibition out there.
I think Satya Krishnan want to talk, that we will ask him to talk after we finish up the questions. Okay. Either a limit of giving the loan and what if the loan is not repaid. Limit of loan we actually discuss. And if the loan is actually subject to whatever the security which is given during the period, that is what he has actually said. In case of the default, further loan cannot be given. Correct?
Yes, sir. Very much. Very much.
Okay. Either any difference between the Nidhi and the mutual benefit society?
See, mutual benefits.
Society, I don't know. Society, I don't know, because in fact, even the Nidhi company is actually known as the mutual benefit company, I believe.
Yes, Nidhi Company actually is a mutual benefit fund or Nidhi Company. This is the name which was being continued from initially.
Yeah.
And now with the advent of the new Companies Act, every mutual benefit company should be having the prefix Nidhi with that. At the same time, society is again different.
How to get the NDH4 license? I think NDH4 we spoke enough actually. Can we take up the name in case no further work is done, no filing is done due to NDH4 license not received?
I didn't get the question, sir.
He said, can we strike it off, the Nidhi company, if we are not, no work is being done and no filing is also done and the NDH4 approval is also not received?
I believe there is only option to either strike it off from our end, or ROC will strike it with default on
Either
the
to strike
director.
off or to go for voluntary liquidation. These are
Okay.
the two options available.
How to
Yeah,
complete 200
And even
members?
for
I-
striking off,
Yeah, sorry.
can I continue?
Yeah, Dipti, you are saying something?
I think for striking off also the compliance is first necessary. They will not allow striking off like that. Or they themselves will also not do.
No, no,
But madam,
before
this NDH4 is rejected. I am not able to do anything.
But there is a reason you have to follow.
No, because the problem is NDH4 is rejected. There is no question of resubmission, etc. and other thing which happens, no. There's a problem because you only receive the rejection. That is what you are telling. That is why he also said that the matter went to High Court, etc. and other thing.
Once NDH4 is rejected, we have only one option. Go
That's
to the
all.
High
You have to
Court,
close down.
refile. Go to the High Court, then get the order, refile. Then what the High Court is saying is that do everything good. So do everything good at that time, get it approved, then go for strike off. But there is no point in going for strike off after getting it approved.
Okay.
Yes, sorry, Mr. Satishin was telling something. I interrupted. Sorry.
Oh, that is that. If we do not get that NDH4, either the company has to contest before the judicial forum, or it has to wind up voluntary liquidation, or to get it strike off. But if we go for strike off, again we have to file the balance sheet, everything update. If we are done business for one day, then they insist for filing of balance sheet till date.
How to complete the 200 members before filing the 20A? I think you discussed actually what the promoter do, what is the practically which is actually happening.
Practically, what they are doing is they are joining, getting 200 members joined as members with a 10 rupees.
Nidhi Limited not considered until approved. That I think we discussed enough actually on this matter. Any Nidhi company got NDH4 license after amendment 2022? If yes possible, can you share the name? He said
think
no,
three
actually.
companies.
Only 3 companies he said actually.
That is my information. I don't know whether more companies have got it, but recently somebody was telling that only 3 companies have got it.
Magesh Kumar also supporting you. Currently, they are not approving the name also. That is what he is saying here.
Yes.
Because the one thing is there, especially after the 2024 amendment, which has actually come, the name Nidhi Limited, unless NDH4 is approval is given and other thing, and all the name itself is getting rejected, I believe. The common reason for rejection is the word Nidhi Limited, but not considered until approval of the ministry. That is what he is sharing here. So if the NDH is rejected, there is no use of the incorporation Nidhi company. What are the options available to promoter in this request? You said actually it is either the liquidation or the strike up, whatever one of the method, or the third thing is you go to the High Court.
But the practical problem is,
yeah,
a Nidhi company, they might have given a lot of advances, loan to the members. And if you go for, if they understand, or if you know that you are going for voluntary winding up, that money will not come back. Practically, it will not come back. So that would be a very burdensome to the promoters.
I think Mr. Murthy is saying, I have one doubt that one of my friends has started the Nidhi company. So when they started the name of the company is approved, but after the process, it is rejected, and he also paid the stamp duty. Can you please tell me what are the issues or can come up? Please clarify what is to be done.
Have the department mentioned any reason for rejection of this?
Can a Nidhi company accept any amount of the advance or loan or deposit from its members? I think deposit you actually discussed, loan also you discussed. He is
Yes.
using the word advance.
Sir,
Only
can you please?
deposit. Only deposit can be accepted. Nothing
Yeah.
is said about advance.
Okay.
If it is the advance is in the nature of deposit, okay. Otherwise, not.
Okay. Satya Krishna is asking, what do you suggest? Can we restart the incorporation station with the new directors, not a director of any other company, all over again? I think after the rejection happened, that's what he is talking.
This is again related to
No.
rejection of incorporation.
NDH 4.
No, Nidhi rules doesn't say that a director of a Nidhi company cannot be a director of any other company. It only says that a director of a Nidhi company can be a director of not more than 5 Nidhi companies. So apparently, he can be a director of 5 Nidhi companies plus 5 other public limited companies plus 10 other private limited companies. Total 20 he can go.
That is right, but I got
There
another
is no-
things in my mind. When he says, once he applied for the Nidhi company, it has got rejected. And he says that I will once again start the incorporation process. What is the surety this will get approved again? Same problem we will face. No?
Same problem, sir.
Incorporating a new company.
Yeah. Nidhi Company Incorporation in 2018 recently received a NDHR 4 rejection letter from MCA citing non-compliance with the Nidhi rules, seeking urgent guidance on rectifying the issues to avoid further regulatory action from the RDROC. What are the ways forward to avoid further notices communication from the MCA? Can the Nidhi Company go directly for the strike off since it has not received the show cause notices from the ROC yet? So the company can go for it. It reduces and the matures the deposit, premature deposits, and also, but the reducing the deposit and the loan taken in time, let us say 3 months after the between the notice penalty comes from MCA, then what should we do with this? Please tell you the ways, how can we go about it? I think specific question cannot be answered. One thing. Number two is already discussed here. Only thing is in such a circumstance, there are only 3 possible ways. There one is actually either go for the liquidation or go for the strike off, or the last one, which was actually a time taking consumption of going to the High Court, etc. That is what. But the compliances will be required to be done. Because as he rightly said, if the business is actually done, the loans is given, deposit given, all those things has to be taken care of.
That is right.
Yes,
Not only
Kadri,
that,
I look forward from you. Yeah.
Yeah, see.
If there is any deposit outstanding or any loan to be repaid, we cannot go for strike off. We can go for strike off only when there is no other assets or liabilities other than paid up capital or accumulated loss. So the accumulated loss and the paid up capital should be equal. Then only we can go for strike off normally. Then the other next option is go for voluntary liquidation. But the voluntary practical problem that may face by the companies, the advances that the company has advanced has given to the members, that may not come back. They will deliberately, they will skip the repayment once they know that we are going for liquidation.
How MCA can expect the pan from the agriculture?
Sir, one more thing I would like to add in this.
Yeah.
See, all the cases which we have come across here, immediately we approach the High Court. When we approach the High Court gives us a blanket order is there, which is given for almost all the Nidhi companies, and whereas there is an association who have gone, for everybody, High Court has allowed them to raise 10% of the capital and accept 10% of the deposit. I think this is the two conditions High Court has given. And alternatively, High Court has asked to approach the ROC as well as the RD and go for compounding of the offences which NDH 4 states. NDH 4 may state 1, 2, 3, 4, 5, 6 issues why this is being rejected. So we can go to the ROC and go for an adjudication for matters which are related to adjudication. At the same time, approach the RD, go for compounding, get this compounded, and after doing all this, you have to refile the NDH4 and make it good about the past. If the extent is such that it can be made good with the compounding and penalties. After that, you can file this NDH4, get it approved, and continue your business. We are in the process of doing that for 2-3 companies, so that is happening good. And now when we go to ROC, this till this new incorporation issue is there. At the same time, when we approach ROC a few months back, they were like, we don't know what to do. You go to MCA's HQ. That was the response from ROC. But now ROC is saying, you come with the problems, you apply for adjudication or compounding and get it done. So ROC has come with a solution for these problems now. But this is the only way to solve it out. First, we have to approach High Court.
But High Court doesn't take a lot of time.
Sir, immediately I think Satish sir can also please comment because actually what happened is but 2 years back when this NDH4 was rejected in 1922, they approached the High Court. The High Court gave an interim order saying that the status quo will be maintained and plus they can also admit 2 members up to 10% of the present members. If there are say 400 members at that time, another 40% can also be added as members and they can continue. That is what High Court said in the interim order. Now the final order has come recently, say 3 weeks back, maybe 20th of April or so. And in that order, they have clearly stated that whatever mistakes that the RD or ROCS found out, that should be compounded or cured. And after that, you have to file NDH for afresh, and then the department has to approve it. If it is not approved by this regional director or the concerned MCA, then they have the liberty to approach the High Court again. That is what the order says.
Nidhi Company incorporated to 5 lakh rupees paid up capital. NDH4 cannot be filed as minimum 10 lakhs paid up capital. I think now it is 20, I think. Is required.
Now it is,
and PA3 cannot be also filed as
but net
NDH is not filed.
Sir,
What
actually,
can be done?
the rule house said that, okay, you have to comply with this 22 amendment. Even though you have followed the previous rules.
From the agriculture whose income is exempt from the tax, Rule 2DA definition, Nidhi, is whether constitutionally valid.
But all questions are attended, I think.
Yeah, all questions have been answered here.
So
Almost.
then we will allow that unmuting and the people to speak then.
Please, sir, please, madam.
So whosoever
That we look into.
speak, we will allow them. Please raise your hand so you will be unmuted and you can speak, please.
Hello.
Thank you.
Hello.
Yeah.
Thank you.
Am I audible?
Yeah, you are audible.
Yeah, thank you, ma'am. So, sir, I have one doubt that a company was incorporated in 2018, a Nidhi company. The form NDH4 was filed in 2021 December, which was again late filing. And just 2 weeks back, we have received Nidhi for NDH4 rejection notice from ROC Mumbai, wherein they have cited various non-compliances regarding unencumbered deposit, then shareholding pattern, and various DPT3 non-compliances and all. And by citing those reasons, they have directly rejected the form. And in the end, it was like copied to RD ROC as well, wherein they have given that to take appropriate action under violation of Nidhi rules and Companies Act and all those things. So immediately after that, what client has done, that he has stopped taking the deposits and providing loan and everything, and now he's trying to premature deposit and recover loan from other people, and trying to like kneel down all the transaction. But as on now, like, what would be your suggestion to go ahead to avoid other show cause notices or any other penalty notices, and directly we can go for strike off for this company? So what would be your valuable suggestion for that?
Yeah. See, this, what are all the points which have been part of the NDA's rejection form letter? Each point shall be taken, and whatever can be made good, you shall make it good. And alternatively, you can approach the High Court for an interim order, because the present order, whichever has come from Kerala High Court, can also be quoted. And you will be better to say whether these complaints which can be made good can be, which is definitely based on the rejection list. So that shall be analyzed and can take up. If your deposits as well as loans are huge, I don't think it will be easy for you to go for strike off also, like sir have just mentioned before. So immediate solution is to approach the High Court, and you can run your business with that 10% permission with the High Court will immediately give. Alternatively, you can approach the ROC or RD and do the compounding or adjudication, whatever is required, and take it forward.
Just thank you so much for the answer.
I'll request participant that we discuss that, there is a rejection, a problem on setting up new company approval and all that. So we cannot comment on anything and we cannot make any judgment. We can just discuss the facts. So set aside that. Any other question, please? If there is, I think we have covered everything, and everyone has this problem. We know that, and even our panelist has faced this. So other than that, any other compliance issue or anything, you can mention that. Otherwise, we'll close the webinar. I think we have covered everyone. I think no one is there.
Yes,
So we can close this webinar. Yeah. Thanks everyone. Thanks for your participants. And actually, when we started this webinar, as everyone, we were thinking the participants will be less, and we will not get many people. But we appreciate that you all, as usual, has supported us, and we always above 100, and it is there. Thank you, Mr. Satisan. It was really wonderful, the kind of experience, the time and efforts you have spent with Arun also, and the PPT, and your sharing the knowledge, experience. It was wonderful to have it on our panel. Thanks a lot for your time. Thank you. Arun,
thank you so much, sir. Thank you so much.
Arun, you have gone through so detailed this time. It was wonderful. And it shows your years of experience in handling Nidhi Company. Thank you.
Thank you, madam. Thank you so much.
Thanks, Sudhakar. Thank you, Mr. Bala. Thanks, everyone. Let's meet next week. Thank you. Thank you, everyone.
Thank you, madam. Thank you, sir, so much.